The first matter before the court is Lincoln 2430, Kelly Mitchell Davis versus Squirrel Island Village Corporation et al. We are being streamed live on the web both by audio and visual. I would ask counsel who will be arguing to identify themselves by saying your names for the record, together with the party that you represent.
Joseph Baldacci for the appellant.
Sam Johnson for the appellee, Squirrel Island Village Corporation, Squirrel Island Association, and Squirrel Island Historical Society.
Okay. And you will be arguing for all appellants?
Correct.
Thank you. I mean, appellees. Thank you. Mr. Baldacci, if you're ready to proceed, we'd be happy to hear your argument.
Thank you very much, Your Honor. And may it please the court, good morning. The standard of review for a motion to dismiss is that the allegations in the complaint in relation to any cause of action that may be reasonably inferred from the complaint are to be admitted. They are to be viewed in the light most favorable to the plaintiff.
Counsel, I see that.
Oops, sorry.
Go ahead.
No, please, go ahead.
I see that you've chosen to let the green light go on right away. In your complaint, you allege that she is an heir, that Ms. Davis is an heir, and by virtue of assignments from others, arguably the sole heir, correct?
And I also use the word owner.
Owner.
Yeah.
You do. But I guess I'm trying, does this court or do the state courts, as opposed to the probate court, have jurisdiction to determine who is an heir?
Well, that's a fact. That's not an issue here. We are asserting that she's the owner. We have a good faith basis to assert it. We are entitled to have that determination.
Well, but we don't have to accept legal conclusions, and ownership is really a legal conclusion, if it is otherwise belied. Then that's why I'm trying to understand how she could be the owner based on the allegations in the complaint.
Based on I understand what the court's saying, but the probate court could not handle a case now because of the fact that it would be more than 6 years from the time that Ms. Ronco passed away. Well, the town, however, treated her son, that heir, as the owner and dealt with him for a number of years after Ms. Ronco's death. The property was not demolished until 2018.
Counsel, there is a 3-year statute of limitations on probate proceedings, but there's also an exception to that for determination of, for construing a probated will or determining heirs. And in the Reed case, we approved a late-filed, probate court's handling of a late-filed, years later, claim to determine the heirs and recognize that exception. So again, why doesn't if there is a question of the rights of Ms. Davis versus any other potential heirs, why isn't this in the probate court?
Your Honor, in a motion to dismiss, the facts are to be accepted as they are. There's no countervailing proof otherwise.
This is a jurisdictional issue.
Yeah, and I feel that we need further discovery in terms of hashing this out and whether it exists that way or not. This is a complicated case having to go back many years.
But counsel, the problem is that you've alleged that she's an owner. You've alleged, and satisfactorily alleged, that there was a discussion of a lease to Sadie. But you've not alleged how Ms. Davis becomes the owner of a leasehold.
Well, first of all, there are multiple theories. There are two theories. One is ownership, and the other is lease. This property was occupied by their family historically before there was even a Squirrel Island Corporation.
Are you suggesting you're making an adverse possession claim?
Well, if I could just complete my train of thought.
Go ahead.
I'm suggesting that they were the owners. If you go through the records that we cited in the complaint, the Indian store has been there and they have recognized that they have been occupying it for tenting purposes for many, many years. So there's a historical record, and it's our argument in the complaint that the corporation has a limited charge from the legislature. And that limited charge, it's not a municipality, that limited charge, they can only do what is in that charge. And part of the complaint is that they acted ultra vires on a number of things. One is that this individual owned the land, and by the way they both recognized her as occupier and the fact that the 1903 legislation that created SIVC specifically states that for the purposes of taxation under this act, the person or persons entitled to the use or occupation of any lot on said land shall be deemed the owner thereof and be taxed for said lot and improvements, if any, thereon.
If I can, I just want to derail your train of thought for just a moment.
Sure.
It seems to me, you may disagree, but it seems to me that the 72 lease to Sadie is very pivotal in our analysis here. And as I look at, in your complaint, you cited the vote of the Board of Overseers where it says, it was voted unanimously, the corporation will give Ms. Sadie Mitchell, this is verbatim, extended a self-extending lease for periods of 5 years to up to 100 years on the property she now occupies. That was a vote of an organization that didn't have the prerogative to grant a lease, and it's prospective. It says the corporation will give Mrs. Sadie Mitchell a lease, but I can't find anywhere else in your complaint that a lease was actually created and
Well,
delivered.
I think that we would need to, that's the whole purpose of discovery and moving beyond a motion to dismiss.
But don't you have to allege it in the complaint? I mean, it basically says, you know, if John Jones says he's going to do something, and you have to, and the whole complaint surrounds what Jones does, but you don't actually allege that Jones did it. Doesn't the complaint fail?
No, I think that the fact that there's a documented record of the lease, at least by the town minutes, I understand what the court's saying, but there is by the town minutes, and that's all, and the continued practice of what happened over the next 30, 40 years, not just with her, but with her son, who is Miss Davis's uncle.
This may be extrajudicial, but does anybody have a lease in their briefcase today? No?
That would be extrajudicial.
All right, so we
and it
won't
would
even
be-
go there. But
And
I'm
it
just
would be
saying,
beyond a motion to dismiss.
it is. I'm just saying it's the allegation is missing from the complaint, as if to say, you say they're going to do this, and I would have expected to say, and in fact, the lease was in fact executed, delivered to Miss Sadie Mitchell.
Well, I tried to show through the history of what happened, that is what happened, Your Honor, and that's why we need to move beyond the motion to dismiss.
Well, counsel, excuse me, but
Yes.
history is one thing, but documents are another. So let's assume, just for the sake of discussion, that pursuant to that 1972 vote, a lease was actually executed. Where is it? And doesn't the statute of frauds, if there's no writing evidencing that conveyance, doesn't the statute of frauds prevail here?
No. First of all, the town minutes itself is in writing. Second of all, this is a motion to dismiss. That may be a factual issue that has to be gone through discovery and maybe on a summary judgment motion. I think it's premature for us to make these conclusions on a motion to dismiss.
So you cite the Beal case in support of your position, but Beal actually held pretty clearly that the minutes, to the extent that they can substitute for a lease, have to either specifically convey an offer, which is accepted, or specifically convey an acceptance in the minutes. That's not what we have here. In fact, Beal was pretty careful to say, if it's just some expression of future intent, it doesn't qualify under the statute of frauds.
But if we had to litigate that case, Your Honor, the fact is that the subsequent practice of the town in dealing with her and with her family would be also further evidence of a lease. And I'm just saying there are huge factual
Or it could be
conclusions.
evidence of a license, in other words, that they let her be there. But that, doesn't that
you're-
come,
yeah.
let me finish, but doesn't that come back to where I sort of started, is how, if there's nothing in writing, how is there any kind of property interest, whatever the nature of that ownership is, that can and did pass to Ms. Davis?
Your Honor, we have two theories. One is lease, and one is ownership. She was.
But don't
she
both
was
of
an
those
owner. It's going to be our contention through discovery that she was, in fact, an owner of this property based on the record.
But whether it's ownership or leasehold interest, either way, doesn't that interest in property have to be in writing before it could even pass, whether through testacy or intestacy, to an heir?
It is our position, as stated in the complaint, that she was entitled by virtue of the bylaws of the corporation to be basically given a share or become a shareholder.
She meaning Sadie?
Yes. According to the bylaws, the association leases almost all of the platted lots on the island to individuals for terms of 999 years for use as seaside residences for the families of the lessee. It's clear that she has resided there, that they operated this store.
But when you say, sorry for interrupting, when you say owner, you said we're talking about ownership and lease. When you say owner, it was my understanding in reading the materials here that the association basically owns all the property and they lease it out to people. Are you saying she has a fee ownership in the property there, or is it something else?
Possibly based through discovery, but she has a property interest, Your Honor, and that property interest she was discriminated against. Native Americans didn't have the right to vote until 1950, so she was, in fact, the original plates, I think I cited here in minutes, their original location was moved sometime in the 30s to put them next to the town dump. They had an interest equal to everyone else that is on that island, that's enjoying that island. They were never recognized as that. They've been discriminated against. I understand the court's point about the probate matter, and we can certainly add a count here for declaratory judgment. The Superior Court could decide that issue. It's not solely, the Superior Court could decide that issue, or we could, depending on how the facts turn out, but we are alleging that she is the owner by virtue of those assignments, and there's nothing that's been presented to us to counter that.
But you also have no documentation for having received a share or a half share, do you?
No, she didn't receive those because she was a Native American, and because she was not treated, that's part of my claim, is that she either ownership or lease. Either way, there was no judicial process. And if anything, I would argue that her son, who continued operating it until it was demolished in 2018, who is given his rights completely to, as well as all the other heirs of Ms. Ronco are given their rights to the appellant, that we have at least made a good faith basis that under a motion to dismiss, the motion to dismiss should be denied. We should be allowed to at least proceed with some reasonable discovery. And I think many of these issues involve both legal and factual conclusions. And I respectfully ask the court to consider that and the documented history, because it's clear after 1972 that they dealt with her as a leasee, if you will, a person with property, and then they also dealt with her son as the inheritor of that.
Thank you, counsel.
Thank you, Your Honor.
Good morning. May it please the court. My name is Sam Johnson, and I represent the appellees in this matter. I do think the court keyed up on the two major issues before it on appeal.
Well, we did, but let me back up for a moment. Again, this is on a motion to dismiss based solely on the allegations in the complaint. You agree?
I do agree with that, Your Honor.
And the order below for the motion for the Squirrel Island Village Corporation and the motion of the Squirrel Island Association granted the motion to dismiss on the grounds of lack of standing, right?
Correct, Your Honor.
So we look at the allegations in the complaint to see if there is a sufficient injury or interest alleged, correct?
Correct.
So she alleges she's the owner of this property. I understand there may be reasons why that may not in fact turn out to be the case, but don't we accept that for purposes of a motion to dismiss?
And I think in your earlier questioning, you hit the nail on the head. You accept factual allegations, but you're not required to accept legal conclusions asserted in the complaint. Based on the four corners of the complaint, the both standing and the cognizable justiciable interest are both legal conclusions, saying I have standing based on a theory of being in heir and having an assignment, none of which are attached to the complaint, the amended complaint, in opposition to the motion to dismiss or before the court on appeal. The theory, and I think Justice Douglas pointed this out, is there are legal mechanisms to have that determination made to give you the legal standing, which would be a prerequisite to filing this lawsuit and having standing to assert the claims.
You're talking about the probate.
Correct, correct.
Do you agree that there would be an exception to the 3-year statute of limitations?
Yes, Your Honor. There would be an exception, as you said, A, for determining heirs and determining the scope of the will as well. And to the extent that exception did not apply, there would be...
But aren't you really saying, well, she's not really an heir or it hasn't been determined, all things which are not discernible necessarily from the complaint as pled?
Your Honor, again, based on what is in the four corners of the complaint, the allegations are insufficient to establish a legal standing to assert claims in a lease, as step one. And then as step two, as the questioning pointed out earlier, you have meeting minutes as the sole basis of this lease, which again are some future intent.
All of which may be good reasons why they may not be prevail. But I guess I'm curious, for example, if you were to bring a tort claim and assert a, loss of consortium, both a claim and also a loss of consortium, you would allege, I am married to the other plaintiff. You wouldn't require that they produce the marriage certificate as part of a motion to dismiss for a lack of standing. You accept that allegation?
Correct, Your Honor, in that context. But I think the existence of the probate system is what distinguishes this from a run-of-the-mill tort cases. There are prerequisites to determine who has rights in a property, and it requires there to be a personal representative or an executor, and for those rights to be determined and for those property rights to be distributed. There's no allegation that occurred, and in fact, the...
But if I bring a claim against somebody saying, your car ran into the front of my house and I own that house. I mean, again, you're not going to question whether I actually own the house at that pleading stage.
Again, I understand in the tort context, I do think the existence of the probate system is what distinguishes it. I think it was discussed in the transcript of the oral argument below, but we did a search for case law where cases have been brought as an heir of someone as a plaintiff for rights and property, and we were unable to find any. And I think that's a telling fact that there is no cognizable legal standing to be an heir of someone. An heir is like a future intent with a contract. You may or may not have some future interest.
Well, the amended complaint changed the caption from heirs of Sadie Ronco Mitchell to simply Kelly Jo Davis, didn't it?
Correct, Your Honor. The allegations...
Same, essentially, because she's the owner.
The allegations, though, remained the same, that there was several deaths and intestacies and assignments, and again, I think as a threshold matter, there needs to be a determination of your legal interest in that property, and there needs to be some determination, again, as a threshold matter from a legal standpoint, that a lease existed, the lease was assignable, the lease was assigned through these deaths and intestacies, and now Ms. Davis is the sole owner of a lease that, again, the only information we have in the complaint is a future intent to take some step that there's no allegation that occurred. And again, that goes back to a legal conclusion the court is not required to accept.
The complaint alleges that a store was operated on the property until 2019. What's your view of the basis, the legal basis for the operation of the store? And that's a fact we have to assume is true for purposes of the motion, right? The store was in operation continuously until it looks like 2019, according to paragraph 2 of the complaint.
I don't think the operation of the store changes whether or not there is a property interest
Well, what
belonging.
was the basis for the operation of the store?
I mean,
Was it
there
a
could
tenancy
be,
at will or what?
it could be a tenancy at will. It could, there, I mean, there could be many theories of the operation, but I think for purposes of the motion to dismiss, that operation doesn't establish a property right held by Ms. Davis. It doesn't establish that she has standing to assert property rights that may or may not have been issued in 1972 to her great-grandmother. And I think
Counsel, is the Irwin memo part of the complaint?
it was not, Your Honor.
Why not? Well, it wasn't part of the complaint, but for our review purposes, should we consider the Irwin memo?
I don't believe so, Your Honor.
Why not? It's a public document.
A public document issued to the, as part of the Squirrel Island Village Corporation. It was, I mean, at the trial court level, there was no basis asserted for why this document could be considered. It was objected to as being outside the four corners of the complaint.
Understood, but just under the Moody case analysis, doesn't it fit within one of the exceptions?
I don't believe so, Your Honor. I don't believe it falls within any of the exceptions enunciated in Moody. And to the extent that the court determines it does, I don't think it helps appellant's arguments on appeal. I think it establishes both that if a lease in fact existed, there needed to be a writing from Squirrel Island Association for that to be assigned, again, absent in the complaint.
Speaking about that, I've been kind of focused on the events of 1972, thinking that maybe that's the tipping point for the whole thing. I'm going to ask you two questions. The first is, does anything that happened before 1972 inform what our decision is here today? That's my first question. The second question is, if the lease was personal to Sadie and the corporation determines who resides upon the island, does Sadie have the prerogative or legal ability to assign, bequeath, or otherwise have her interest in that lease go to someone else? So two questions.
Okay. So,
It says 1972, a tipping point. We just look at that point forward and look at the past. Number two, is it personal to Sadie? Can someone else jump in after the fact?
so to answer the first question, Your Honor, yes, I think based on the four corners of the complaint and the allegations asserted, 1972 is the tipping point. I don't think anything that happened before 1972 is going to be necessary in reviewing whether the allegations of this particular lease, whether they're standing, whether there's a justiciable claim. To answer your second question, again, there's insufficient facts in the complaint to establish that the lease issued to Sadie, if one was in fact issued, and again, based on the language in the complaint, there's never an allegation that this lease was issued. Here are the terms of the lease. Here were the parties between which the lease existed. Here are the terms sufficiently definite for the court to affix a meaning to. So again, there's insufficient facts in the complaint to establish the lease existed. There is no claim that the lease in fact existed and was assignable and then was assigned to, Sadie Mitchell's son and then assigned to Miss Davis. And I think to go back to a point raised by Justice Douglas, if the court were to consider the memo attached to the opposition to the motion to dismiss, there's language in there that says these leases are not assignable and without written consent of the Squirrel Island Association. And again, there is no allegation in the complaint that Squirrel Island Association authorized in writing a lease that may or may not have existed to be assigned and to whom.
Counsel, if we were to determine that this is a matter that should have been brought in probate court to determine the heirs, and that therefore there's no jurisdiction in the Superior Court dismissed this case with prejudice, would the outcome change? If there's no jurisdiction, would it be a dismissal without prejudice?
Your Honor, I believe the dismissal would remain with prejudice. It's a plaintiff's or appellant plaintiff's prerogative to choose the correct venue and to file in the correct venue, and failure to do that would result in a dismissal with prejudice.
If probate proceedings were undertaken and a dispositive answer was provided to the ownership, basically a new scenario, a whole new story, would that provide a launch pad for another effort along the same lines?
And I hate to speculate, Your Honor. Again, my understanding is the dismissal with prejudice, given the choice of venue, whether it was premature or not, would operate as a bar to future claims based on dismissal. But I can say, Your Honor, that obviously a determination of rights and property may have an effect on whether that dismissal is applicable to the claims that were actually asserted in this lawsuit.
Should a dismissal for lack of standing, however, be with prejudice?
Your Honor, I believe, again, that a dismissal for lack of...
The whole point is it's saying it's not justiciable and that it's not being adjudicated on the merits.
It's not an adjudication on the merits. It's an adjudication of your inability and lack of standing to bring a claim, which,
Sure,
again...
but if tomorrow she came back and said, here's the probate determination that I really am the sole heir, et cetera, I mean, isn't that error, even if it's correct to have dismissed it for lack of standing, isn't a dismissal for lack of standing necessarily without prejudice?
Your Honor, so I believe the dismissal would be with prejudice. I'm not saying there aren't arguments that, as you pointed out, that these are now a different set of facts before the court because this has been determined. This was not a determination at that
So
point.
facts may come out of the probate court, which would provide a solid platform for standing.
It's possible, Your Honor, but what I would say, again, for purposes of this appeal, is the four corners of the complaint that are currently being reviewed do not establish the necessary
And I
facts.
understand that, but I guess I'm challenging you on whether a dismissal for lack of standing, it can be a dismissal with prejudice.
And Your Honor, I guess my understanding is that determination is that you lack standing, you don't have the ability to assert the merits that you are trying to assert.
But it's not a determination on the merits, is it?
It's a determination of your inability to prosecute the merits of your claims.
Right, which could change tomorrow if somebody assigns something to me or whatever. I mean, in general, I'm talking about.
In general, Your Honor, then I believe under those set of facts, it could be a dismissal without prejudice. Again, my understanding based on the inability to assert those claims, it is a determination on those merits.
There was one claim which doesn't hinge on an interest in property, either ownership or lease, and that is the harassment claim. Would it be your position that that claim itself could still be dismissed with prejudice?
I do, Your Honor, just based on the facts that were actually pled in the amended complaint. There are no facts that would establish any type of action undertaken by any of the appellees as harassing. I think the actual count was 2 sentences and repeat and reallege, and these actions constitute harassment. That's a bare recitation without unembellished by any facts in the actual amended complaint about who did harassing, what was the harassing conduct, and how that harassing conduct was
Well, that brings me then to another question, or a related question. So the motion to dismiss that was brought by the Historical Society was under 12b-6 for failure to state a claim, and very few of the allegations were against the Historical Society. And that motion was granted. It looks like both motions were granted on the proposed orders that were submitted, but that motion was granted without further specification. The motion brought by the Village Corporation as well as the association were brought both on standing as well as a failure to state a claim. If we disagree with you on the standing issue, if we were to say, there really are sufficient allegations on standing, what do we do then with the remainder of the motion to dismiss for failure to state a claim or comply with Rule 8?
Your Honor, again, it's a de novo review. If this court were to determine both that there was standing and that she has a legally cognizable interest to be adjudicated, and I believe detailed in our brief, the actual counts alleged in the complaint likewise fail to satisfy the 12b-6 standard. Insufficient.
So even if we thought she had standing, we should go on to the issue of failure to state a claim?
If the court were to determine, again, which we disagree with the standing, if the court were to determine there was standing, then yes, in the de novo review, this court should reach whether each count is satisfied and whether the elements are satisfied by the factual allegations in the complaint and the amended complaint, which we don't believe they are, Your Honor.
Thank you. And Mr. Baldacci.
Thank you, Your Honor. I would just want to focus on part of paragraph 2 of our complaint, which doesn't just rest about Ms. Mitchell's estate, because she died in 1994. Her heirs were her children. One of them continued operating the store with the town's in cooperation with the village corporation, and then his son, who is my client's brother, continued operating until it ended in 2019. They've assigned all of their rights. There's no contravening, there's nothing coming to the court that's saying they don't have these rights. But there's a process for discovery, which is premature now, that can hash out the ownership or leasehold issues, which do require a fair amount of factual determinations, because this family was continuing to operate this as a going concern until 2019. So
And
I think it would be...
the lease referred to in the minutes is said to have been intended to run for 100 years, which means necessarily Sadie Mitchell herself would not be occupying the property during the entire duration of the lease. So heirs, assignees, somebody would have to come into the picture.
Yes, we agree totally, Your Honor. And I think that that was the intent of the grant, because it says self-extending, but also for up to 100 years. And they continue, and their course of conduct is they continue to treat the family members who are mentioned, who have all given their interest to the appellant, to operate this store. So I think I understand the court's concerns, but to say that we have to, and I could understand a need for perhaps a judicial declaratory judgment on the issue as part of a count, but I think that we have alleged sufficient facts to warrant and allowing us to move forward to the issue of discovery based on the history and the facts of this case.
Thank you.
Thank you, Your Honor.
Thank you, counsel. As is our usual practice, we are going to take the matter under advisement. We'll issue a written decision in due course. And with that, we'll be in recess on this matter.